arbitrationagreements.org. Alternative Dispute Resolution, or ADR, presents a way to solve conflicts outside traditional courtroom procedures. And arbitration is a critical ADR process designed to facilitate fair resolutions in an efficient, private manner. Before we go over the specifics of how arbitration works, please like this video, press the subscribe button, and tap the bell for notifications so you can keep up with crucial dispute resolution topics that can save your business a great deal of time and money. Now, let's delve into how arbitration works. It's like a simplified court case, but with a few twists. Instead of a judge, you have an arbitrator or a panel of arbitrators, who are neutral third parties with expertise in the subject matter of the dispute. The process begins with both parties agreeing to arbitration. This agreement can either be pre-existing in a contract or reached after a dispute arises. They then jointly select an arbitrator or a panel of arbitrators. Each side then presents their case to the arbitrator, including evidence and witnesses if necessary. This usually happens in a private hearing. The proceedings are less formal than court, but the goal remains the same: a fair and just outcome. After carefully considering the arguments and evidence, the arbitrator issues a decision, known as an award. Here's the catch. Depending on the type of arbitration, the decision could be binding or non-binding. In binding arbitration, the decision is final and enforceable by law, similar to a court judgment. Non-binding arbitration, on the other hand, allows either party to reject the arbitrator's decision and pursue the dispute in court. Now, you might be wondering why people choose arbitration over traditional court cases. Here are some numbers to put things into perspective. A study by the Federal Mediation and Conciliation Service found that arbitration cases were resolved 60% faster than litigation. Moreover, a recent report disclosed that businesses saved an average of $2.9 million in legal costs through arbitration. The reasons behind these savings are simplified procedures, reduced discovery, and the ability to schedule hearings more flexibly. With advantages like these, it's no wonder that arbitration and other ADR methods are growing in popularity year after year. According to the National Center for State Courts, the use of ADR has increased by over 400% since the 1980s. This trend underscores a shift towards finding efficient, cost-effective means to resolve disputes. Remember, arbitration is about taking control of conflict resolution. It's a viable alternative that has the potential to save time, money, and relationships. Do you need more information about the arbitration process? If so, head on over to arbitrationagreements.org. That's where you can buy the service or program you need and begin the dispute resolution process ASAP. Now, our association does not provide any legal advice, but give us a call if you or your business are considering opening a new account or case. Countless companies and individuals utilize our services to handle claims in a controlled manner through cost-effective solutions. If you're interested in doing that as a business, we are standing by. Successful companies depend on arbitration to save money. You're paying one service per case instead of experiencing the uncontrolled expenses of a standard lawsuit. That's the key reason why arbitration is so popular. Also, what do you think about the advantages of arbitration? Which one is your favorite? Give us your opinion by leaving a comment below. Don't forget to like the video, hit the subscribe button, and ring the bell for notifications so you can stay up to date about alternative dispute resolution processes that can save you time and money.